EAA's webinars are made possible through the generous support of Aircraft Spruce and Specialty, serving homebuilders and EAA members since 1965. Tonight's presentation, Liticaphobia, the fear of being sued. And our presenter, Mike Bush. Mike is president of Savvy Aircraft Maintenance Management. He's an author for numerous aviation publications. He holds a certified flight instructor's certificate, a A&P mechanic certificate with the inspection authorization privileges, Aviation Maintenance Technician of the Year, honored by the FAA in 2008, and a member of EAA. Mike, thank you so much. Happy New Year to you. I'm going to turn control of the presentation over to you.
Well, tonight's webinar is a little bit different. Hopefully we'll have a little bit of fun with it. It's the subject is liticaphobia, the fear of being sued. As usual, I'll be starting this webinar off with a story, and then kind of working towards the point of the story. Most of the time, it's a story about some aircraft owner in distress that calls me with a problem, but this time it was actually my own problem. Let's see here. I spent all of September and October flying all over the country, living out of the back of my airplane. It was the longest trip that I can remember taking in many, many, many years. I left in the beginning of September, started off in Norman, Oklahoma, teaching at the AOPA regional fly-in there, then wound up going up to Boston to have a meeting with the FAA, then back to Tennessee, where I spent a couple of weeks visiting my friend Paul New and doing an annual inspection on my airplane in his shop in Western Tennessee. And by the time that was over, it was the beginning of October. I flew up to Boston. I spent a few days there visiting with my sisters who live in Boston. And then the first weekend in October, I hopped over to Groton, Connecticut, to do the AOPA regional fly-in that was there. My itinerary from Groton took me to the Outer Banks, North Carolina, to Raleigh, North Carolina, down to Pompano Beach, Florida, over to Tampa, where I did the final AOPA regional fly-in of the year in Tampa, Florida. And then finally, at the end of the month, flew back to California. So it was this was just part of my trip. This was the October part, and you can see I covered a lot of ground, and it was really fun. I did a lot of flying and saw a lot of cool things and had a really, really good time. It was it's really nice to be able to take a 2-month trip in your airplane. I was glad to get home by the end of the 2 months, but it was a lot of fun. But at any rate, the story I want to tell you tonight actually occurred in the middle of the month when I was at the Outer Banks in Manteo, North Carolina. This is kind of the layout. They have a really nice airport at Manteo called Dare County Airport. Very pretty, uncontrolled airport there. About 15 minutes drive from Manteo across a bridge, you wind up on the Outer Banks. And I decided I was going to spend a week there living in an Airbnb in Nag's Head, and get some writing done, get some work done, make a couple of visits to the Wright Brothers Memorial, which I hadn't been to for the first time I was there. It was about 20 years ago. And it's always kind of a religious experience to go to the Wright Brothers Memorial and see the big sand hill and the railroad track and everything where they launched those 1903 aircraft. I had my Airbnb was sitting on the canal with a deck that was sort of my view. So it was really a great week. At any rate, at the end of my week in Nag's Head, which was the second week in October, it was time for me to make my next hop in the trip, and that to fly over to Raleigh, North Carolina, about an hour flight in my Cessna 310 from Manio from the Outer Banks. So I checked out of my Airbnb and drove my rental car to the airport at Manio. Here's what the airport looks like. It's a really pretty airport. It's uncontrolled. Has a very nice runway. I think it was about 3,500, 4,000 feet long. GPS approach. It was IMC the morning of my departure. The about 400-foot ceiling. So I filed an IFR flight plan from Manio to Raleigh Durham International. As I said, checked out of the Airbnb, drove to the airport, loaded up the airplane, returned my rental car, pre-flighted the airplane, taxied out, called ATC for clearance. They were able to copy you on the ground at Manio. And I did a my usual pre-takeoff run-up, including a mag check and so on. And that's where the fun began, because as I was doing the pre-takeoff run-up at the end of the runway 22, about to take off, this is a piston twin, so the mag switches are not a key-operated switch. They're actually 4 little toggle switches. And to do the mag check, you at run up RPM, you cycle each switch off and back on and see what the RPM drop is, make sure everything runs smoothly. But when I turned the leftmost switch off, which killed the left magneto on the left engine, the left engine quit, which meant that the right magneto wasn't functioning. When I turned off the left magneto, the left engine quit. So apparently it only had the left engine the left magneto was the only functioning magneto. Well, that's not a good thing. I've done this run up a million times. I've owned this airplane for 30 years, a little more than 30 years. And I've never experienced a problem like this, but it was clearly a hard failure of the magneto. So, of course, I go through all of the stuff that pilots go through when this happens. First of all, I'm upset and I utter some expletives that I'm not going to share with you on the slides. I momentarily think, should I just go ahead and depart anyway? I've got, 2 engines and 3 good mags. And then after about 50 milliseconds, I say, no, that's not a good idea. When I make decisions like that, I always pass it through what I call the NTSB report test, which is if something goes wrong, what's the NTSB accident report going to say? And in this case, it would say the pilot departed into low IFR conditions with a known mechanical deficiency. Well, I don't want that to be my epitaph, so I decided I wasn't going to go with a known bag magneto. So I decided I better taxi back and think about what to do. And of course, as I'm taxiing back, all the stuff that's going through my head, it's a Sunday. There's nobody at the airport. The best thing I could do is get on the phone Monday morning and order a replacement magneto to get overnighted to me, which means I would probably get it midday Tuesday, and maybe I could hang it on the airplane, and it would be, maybe the airplane would be flyable by Tuesday evening. But if that happened, I would have to cancel my appointment Tuesday morning at Raleigh Durham, where I'd made an appointment to do a 4-hour session with a CFI and do my biennial flight review and an instrument competency check. Well, that would go down the drain. I'd have to go back and figure out how to get a hotel or an Airbnb or something and a rental car, because I just checked out of my Airbnb and I just turned in my car. I had a car reserved at Raleigh-Durham, and it was probably too late to cancel that. And I'm going through all of this stuff as I'm taxiing back with this feeling of despair and helplessness and stuff that you always have when you have an airplane problem while you're on the road. So I calm down a little bit and I say, well, is there some alternative to this scenario? I am an A&P mechanic. I do carry some tools in the airplane. Maybe I can troubleshoot the problem with the mag. Maybe I can figure out some way to fix it. Maybe I'll get lucky and it's something real simple to fix. Who knows? Maybe I can figure out some battlefield repair to get the thing working until I can get it to a proper shop. I'm obviously grasping at straws, but I've got to at least give it a shot to see if I can somehow salvage this mission so that all the rest of my plans don't go down like a row of dominoes. So as I'm taxiing back to the ramp, I notice something unexpected. I notice a big hangar with its door wide open. I didn't expect to see anybody there at the airport on a Sunday. It was very quiet and everything looked like it was locked up. But as I came back in, I saw this big hangar. And I decided, well, maybe I ought to head over towards the open hangar. Maybe there's a chance that I can get some help. As I get closer to the hangar and get a chance to look inside, this big hangar it looks vacant. It doesn't have any airplanes in it. Its door is wide open. And all I can see in there is a big red roll-around tool cabinet and some ground support equipment like aircraft jacks and tow bars and stuff like that. But, basically a big, giant, empty hangar with no airplanes in it. So I shut down the airplane on the ramp in front of this hangar and I get out of the airplane. And as I look in the hangar, I spot what looks like a gray-haired middle-aged man puttering around the back of the hangar. I decide to walk in and see if he knows how I can get some help with my problem. So our dialogue goes something like this. I say, good morning, I'm Mike. This is my Cessna 310 out there. He introduces himself, says his name is Sam. It wasn't really Sam, but I'm going to use Sam to protect the innocent here. And so I explained to him I have a problem with the airplane, and I was hoping maybe he could give me some help. He asked me what was the problem. I told him the right magneto on my left engine appeared to be completely dead. He questioned whether it was really dead or just maybe foul plugs or something. And I told him that I checked it real carefully and it was clearly just completely dead. We both agreed that didn't sound real good. So I asked him, would it be possible for me to pull my plane into the hangar, this big empty hangar, so that I could work on it in the hangar with, good lighting and stuff. And he looked at me, the smile never left his face. He just said, no. Well, I was a little surprised by that. So I said, well, is there any chance I could use that red toolbox in the back of the hangar and borrow some tools for a little bit while I'm working on the airplane? He said, nope, I can't let you do that either. And I'm puzzled because he seems like a nice guy. The hangar is empty. There's nobody there, but he just wasn't interested in cooperating with me. So I had a thought, and I asked him, I said, Sam, are you an A&P mechanic? And he says, yes, as a matter of fact, I am. I thought, well, maybe he's looking at me as a competitor. So I said, would you like to try troubleshooting my magneto? And he says, no, I don't have time for it. Besides, I never work on magnetos. I always send them out. So I was getting absolutely nowhere with Sam. He was not about to help me in any way, shape, or form. But I kept bugging him. And eventually I convinced him to lend me a 1/2-inch offset wrench, which I didn't have in my toolkit. I knew I needed to get the mag loose, and a small step ladder so that I could get up high enough to work comfortably on this magneto. And he grudgingly offered to lend me those two tools. So with those tools, plus the tools from my emergency toolkit, I started working on my airplane out on the ramp because he wouldn't let me use the hangar. And it was a long story, which I won't go into. But ultimately, I was able to. I took the mag all apart, and I was able to resolve the magneto problem, put it all back together under kind of battlefield conditions. Return the offset wrench and the step ladder to Sam's hangar, and I was able to depart Manio and fly to Raleigh-Durham, about 2 hours delayed from my original departure time. But it was a nice success story. But not a whole lot of thanks to Sam. He wasn't really cooperating. So over the next few days, while I'm in Raleigh and staying with some friends and flying with that flight instructor and so on, I kept thinking about this incident because it seemed so weird. Sam seemed like a really nice guy. He had a nice smile on his face, and he was a fellow aviator. And I thought, it was just so peculiar. Why did he act towards me in such an uncooperative fashion? And, what would it have cost him to let me pull my airplane out of the hangar and borrow a couple of tools out of the toolbox and stuff? It didn't seem like the way, our aviation fellowship is supposed to work. We aviators are supposed to be helping one another out when we get in trouble. And it just didn't happen in this case. And so I kept thinking about what caused him to act the way he did. And the only answer I could come up with was that he was afraid of being sued. And the more I thought about it, the more I was convinced that was the explanation for his behavior. I believe that Sam just saw me like a lawsuit waiting to happen. First of all, he didn't know who I was. He didn't know whether I was an A&P mechanic or not. I never even got to that part of the conversation. He just started out spring-loaded to the no position. And I remember there's an old A&P joke that the most dangerous thing in aviation is an aircraft owner with a toolbox, and that's probably what I looked like to him. I looked like an aircraft owner with a toolbox who wanted to tear into the magneto on my airplane, something that he already said he wouldn't do. And he's an A&PIA and didn't know I was an A&P. And my guess is that in Sam's mind, he somehow believed that if he helped me in any way to do this thing about taking the magneto apart and trying to fix it, that he felt that if anything went wrong and I wound up, having an accident or something, that he might be held negligent for helping me work on the airplane and that he might get involved in a lawsuit. And that's the only logical explanation I could come up with for his, total lack of cooperation with what I thought were very, very reasonable requests that really wouldn't have cost him anything. Now, one of the reasons I came to this conclusion is that I've run into this sort of thing a lot in the past. Sam was not alone in this thinking. And in my experience, most aircraft mechanics who work on general aviation airplane have almost a siege mentality about the possibility of being sued. And the fear of being sued casts a shadow over every decision they make. And as I said, I've run into this a lot in the past. Just as an example, way back about 25 years ago, long before I was an A&P, I had an eerily similar experience at an airport in Northern California. I had flown in there on a business meeting in suit and tie, left my airplane at the airport, went off to this meeting, came back and asked them to fuel the airplane. I waited for the fuel truck for a while. It didn't come. Finally, a call of nature caused me to go inside and go to the bathroom for a few minutes. And when I came out, there was a fuel truck parked in front of my airplane with a nozzle lying on the ground, and the fuel truck said Jet A. And it was pretty clear that the fueler had misfueled the right main tank on my airplane with Jet A instead of 100 low lead. the fueler readily fessed up to his error, but the fueling company was just a fueling company. It didn't have any mechanics on staff. So I started going to each of the shops on the airport, and there were 3 or 4 of them, asking for somebody to help me purge the fuel system on my airplane of Jet A, so that we could fill it up with 100 low lead and I could get out of there. And none of the A&Ps on the field wanted to have anything to do with it. None of them wanted to work on it. Clearly, they were terrified. All they saw me as being was me. This airplane was a big liability for them. And nobody wanted to help me. I mean, I was an A&P. I couldn't do it myself, but to purge the fuel system on my airplane of this Jet A, which basically consists of pouring avgas in, draining it out, checking the fuel it's drained out for the presence of jet fuel with a paper towel test, and continuing to flush it out until there's no sign of any jet fuel left in the thing, and then filling it up. The fueling company was happy to supply all the avgas I needed to do this. They weren't going to charge me for it. They were really, really frightened about the fact that they had done this. But none of the mechanics wanted to help me. Finally, after many phone calls and a lot of pleading and so on, I did persuade one of the A&Ps to agree to help me if I signed a blanket waiver agreeing to hold him harmless for anything that might possibly go wrong with my airplane for the rest of my life. And I ultimately was able to get out of there, but it was a real struggle. And it was just clear that every one of the mechanics on the field was just terrified to help me, because all they could see was that they might wind up getting sued if anything bad happened to me. So the question really is, and the question I really wanted to raise in this webinar and think about a little bit, is whether these fears that A&Ps have of being sued, this almost siege mentality that I'm talking about, is really warranted. Now, these days, I do a fair amount of expert witness work in air crash lawsuits. It's usually on the defense side. Those are typically the cases I take, are working for defendants, usually defending mechanics, shops, aircraft manufacturers, engine manufacturers, component manufacturers, and so on, overhaul shops, against claims by air crash victims. And I've done a fair amount of those cases like that. I can testify firsthand that aviation is a horribly litigious field. There are way too many lawsuits for my taste, and I do think that the litigiousness in aviation does cast a long shadow over the whole industry, and has some very unpleasant results. And I do wish that we had some tort reform in this country that would have the effect of scaling back some of these lawsuits. But at the same time, I can tell you that, in my opinion, a mechanic's fear of being sued tends to be greatly overblown. Their perception of the risk is far, far greater than what the risk actually is. And the reason for that is the mechanics are rarely the target of air crash lawsuits, because very few of them are high net worth individuals with enough assets to be worth suing. And the plaintiffs in aircraft lawsuits are looking for money, and they typically sue people who have money, and mechanics typically don't have a lot of money, and they aren't really very worthwhile targets for lawsuits, because there just is no there there. In the relatively few cases where mechanics and shops do get sued, the suits virtually always settle pretty quickly within the limits of their liability insurance. Most GA shops will carry $1 million worth of liability insurance. million, 2 million, something like that. And normally the plaintiff lawyers don't, will settle within the policy limits because they understand that there's no more money to be had once they exhaust the limits of their policy. There just isn't, like I said, isn't any there. So most of the aircraft lawsuits that I've been involved in, maybe a shop or mechanic might be involved. Almost never a mechanic individually. Occasionally a shop if it's a big shop and it has good insurance. But mostly the lawsuits target the aircraft engine and component manufacturers, who tend to have a lot deeper pockets and tend to have much higher insurance limits, because that's where that's where the money is, and that's where the lawyers focus. So, from my perspective, and my perspective is sort of from both sides of the equation. I'm an aircraft owner, and I've faced this problem as an aircraft owner a number of times with uncooperative mechanics, and I manage my company manages the maintenance for a lot of aircraft owners, and we face this stuff all the time. I'm also an A&P mechanic, so I kind of understand what it's like from that perspective. And I also do expert witness work, so I'm involved in the litigation side of this stuff. And so I think I have a fairly well-rounded view of this subject. Interestingly enough, this is not a problem that's limited to aviation or aircraft mechanics. This is a much broader problem in our society. Doctors have been practicing defensive medicine for decades. There's a lot of literature on that. Nowadays, teachers are frightened to discipline their students or even hug their students for fear that they're going to be sued for something. Seesaws are disappearing from schoolyards because they're in jungle gyms and stuff because they worry that if a kid gets hurt, there's going to be a lawsuit. I don't know if you've purchased a ladder or a bicycle or a baby stroller or a car seat lately. Just take a look at all of the warning labels on them. The fear level of being sued on the part of manufacturers and so on has just gotten really, really out of hand when I compare it to what it was like 20, 30 years ago. What's really happened is the perception of the risk has escalated completely out of hand. It turns out, if you look at the numbers, the incidence of U.S. civil litigation, tort litigation, has remained essentially flat on a per capita basis since 1975. That we do not have more lawsuits now than we had 30, 40 years ago. But the media coverage of litigation has skyrocketed, particularly with our 24/7 news cycle and stuff. And the media coverage overwhelmingly focuses on the exceptional cases that involve huge damage awards and ruinous damages and so on. Those things happen very, very, very rarely, but those are the cases that we see reported, and they have a lot to do with the perception that people have. This media coverage has created the perception that the risk of being sued is much greater than it used to be, which statistically is not true, but the perception is that it's much greater than it used to be, and that the consequences of being sued are frequently ruinous for the defendant, and that is also not the case. Now, we don't really have any studies of A&P mechanics specifically that I can cite for you, but according to a pretty recent Harvard study, for every 100 people hurt in an accident, only 10 of them will file a liability claim. Of the 10 that file a liability claim, 8 are settled within insurance limits. 2 actually get to court. And of the 2 that get to court out of the 100 people hurt, the plaintiff wins only 30% of the time. And in those cases, those 30% of the cases where the plaintiff wins, the median damage award is about $30,000, which is almost always covered by insurance. So basically, the risk is very, very small, but the perception of risk is all out of hand. Now, as I said, Harvard hasn't conducted a study specifically to A&P mechanics, but if they did, I'm pretty confident that the takeaways would be quite similar. That A&Ps are very seldom sued, as I said, because they typically don't have a lot of assets. And when they are sued, the suits almost always settle very quickly and within insurance limits. So my appeal to shops and mechanics in the aviation industry is to maintain a reasonable amount of liability insurance and then don't worry about it. Do the right thing for your customers without being paranoid about being sued. In the very, very, very unlikely case that you do get involved in a lawsuit, you can be pretty confident that your insurance is going to cover it, and you don't have to let it affect all of your decision making the way it tends to do just all too often in this industry. Enough with the CYA already. So, Tim, that's all I have on this subject. I hope maybe this will open some interesting discussion in the Q&A period. And with that, I will turn it over to you.
Okay, Mike, thank you. Got a few questions that have arrived so far. Let's start off with John's here. He's asking, after settling a lawsuit for limits of liability, what does that do to the A&P's personal or shop insurance? Got any gut feeling for that?
My experience is that if the shop involved does not have a high recidivism rate, in other words, that they haven't had 4 or 5 claims against them in the last 10 years, that their insurance typically doesn't change. We've had my company, it's in the same situation. We carry about $2 million of liability insurance, and we manage, about 1,000 general aviation airplanes. And we've, over the 10 years that we've been in business, we've had, I think, 3 of our clients have died in airplane crashes. And every time, and we just the third one just occurred. We had a client with a Cessna 210 based in Florida that flew to the Bahamas, had some kind of problem, ditched the airplane about 8 miles offshore in the Bahamas. The female passenger in the right front seat was able to get out and was rescued by a seaplane, and then transferred from the seaplane to a helicopter and transferred to the hospital. The plane and the pilot were never found, and after a couple of days, the Coast Guard gave up the search, and so they're presumed dead. And I think that was like the third one in the 10 years that my company's been doing what it's been doing. When these things happen, we always immediately notify our insurance carrier that an event has happened which could possibly cause a claim against us. They turn it over to a law firm who gathers information to prepare for the possibility of defending a lawsuit. We have never actually had a claim against us. We braced ourselves for a claim 3 or 4 times, but never have had a claim against us. And we've never had an insurance premium increase. So that's what I can tell you from my own personal experience. Even though, the insurance companies obviously spent money with the lawyers, and in one of the cases they did a tremendous amount of work in preparation for a claim which actually never came. We ultimately settled with the plaintiff by saying if we will voluntarily turn over all the information that we have, because we had lots of maintenance records and stuff on this aircraft, that they would waive all claims against us, and that was the most complicated of the episodes that we had. But we never had a premium increase, and actually the insurance premiums that we pay are remarkably modest. I'm always shocked at how low they are, really. So that's just my own personal experience with this. I have friends in the industry who own shops, have gotten involved in lawsuits, and they've had to attend depositions and stuff, but I don't think they've ever had an insurance a premium increase as a result of it. It's just been, it's not fun to be deposed by a plaintiff lawyer and stuff, and it takes time, but it was never any kind of a lifestyle changing event for any of the friends I have who have been involved in aviation lawsuits. So that I guess that's the best answer I can give, Tim.
Okay, that's all really good information. We've had a number of people kind of ask questions kind of related to what you just talked about. A couple others that came up here you didn't touch on are, you got any suggestions of different companies that may insure an A&P mechanic? And you mentioned it's pretty reasonable insurance. Some people, ballpark insurance rates.
Yeah, I can't really give you ballpark insurance rates for an A&P, but what we're doing is a little bit different. We're managing maintenance, but we don't actually attack airplanes with tools ourselves. We hire various shops and mechanics around the country to do the maintenance on our clients' airplanes. So I can't really quote you any sort of rates. The company the underwriter that my company works with is an outfit called W. Brown, which is a division of Catlin Insurance, and I know they do a lot of mechanics and maintenance shops. That's one of the areas where they write a lot of insurance. I think there are a relatively small number of underwriters that are in that particular business, but W. Brown Catlin is the one that we use, and they've always been pretty good to work with.
Okay, Gordon's wondering, do you think that this factors into a shop's willingness to allow owner-assisted maintenance?
Without question. Some shops cooperate with it, but to the extent that shops are unwilling to work with owners on owner-assisted annuals and so on, it's largely based on fear of litigation. All of the stuff, the shops that want to coerce owners into performing maintenance just because the manufacturer recommends it at various intervals, and it's not compulsory under the regs, but a lot of shops use all of the coercive power that they can muster to get owners to do that. Shops that are unhappy with doing annuals on airplanes with engines and propellers that are over TBO. All of that stuff is based on fear of litigation. The mechanic's fear is if something happens to the airplane and they wind up being deposed by a hostile plaintiff lawyer, and the plaintiff lawyer says, the manufacturer recommended doing this, why didn't you do it? And that's an uncomfortable question for a mechanic. I mean, the right answer is because the owner told me not to. And that's the right answer, and that's the appropriate answer, because it's not a mechanic's job to determine what maintenance is to be done on airplanes. It's the owner's job. And but mechanics are very uncomfortable with this whole concept. They just, they feel that if they depart from manufacturer's maintenance recommendations and then something happens to the airplane, that they will somehow be held liable. And certainly that it's true that they might possibly be involved in at least the discovery phase of a lawsuit where they have to submit to deposition. And it's, sometimes it's a little unpleasant to be deposed. I've been deposed a lot of times, and, it's not particularly fun, but the chances of the mechanic actually suffering some sort of damage award against him is minuscule. It's just very, very unlikely to happen.
Dwayne is just wondering if you had any advice for a new A&P student coming out of school.
That's a very broad question.
Related to minimizing liability, being, cautious of being sued.
Well, most new A&Ps just coming out of school are at minimal risk because they're going to be going to work for somebody, and they're going to be typically supervised very closely when they're first starting out in the business. A mechanic just out of school is not going to be doing annual inspections or making airworthiness determinations like that, because you have to be an A&P for at least 3 years before you can apply to become an IA and be eligible to do annual inspections. So I think of all mechanics, the newbies are probably at least risk in that regard. But they're probably going to find themselves, or there's a good chance they're going to find themselves working for somebody, somebody who supervises them, who is deathly afraid of being sued, and a lot of that tends to rub off on new mechanics and affect their thinking. It's a very contagious kind of fear, unfortunately, and it's rampant in the industry.
So Charles is asking, do you have any suggestion of what to say if I encounter an A&P who is unhelpful because of fear of litigation? I doubt that I could educate him along the lines you have spoken about tonight.
Well, the best thing I think that owners can do is make their maintenance decisions clear in writing to the mechanic, so that the mechanic has a piece of paper. If let's say a mechanic the airplane's in annual inspection, the mechanic's kind of uncomfortable because the engine is 500 hours past TBO, and he sort of suggests, really you ought to overhaul this engine. It's getting kind of long in the tooth. And you as an aircraft owner say, well, I don't think I want to overhaul this engine now. It seems to be running well. It's not burning oil. The compressions are good. Everything looks good under the borescope. The oil analysis looks good. All the signs are that this engine is healthy. Don't never mind that it's 500 hours past TBO, but it seems to be a healthy engine, and it's really expensive to overhaul it, and I don't really want to do it now. So the best way to resolve that problem is for there to be a piece of paper written that it can be written by the mechanic and given to the owner to sign. It can be written by the owner and given to the mechanic. But it's basically a piece of paper that says, Mr. Mechanic advised Mr. Owner that the engine was 500 hours over TBO and recommended that he overhaul it now. Mr. Owner made the decision that he didn't want to overhaul it now, and declined to authorize Mr. Mechanic to remove the engine from the airplane and send it out to overhaul. Signed by the aircraft owner. Now the mechanic has this piece of paper he can put in his file cabinet, and if God forbid something ever happens to this airplane, and the mechanic gets, winds up in a conference room with a bunch of plaintiff attorneys talking to him, and they say, Mr. Mechanic, why did you sign off the annual on this airplane when it was over TBO? His answer was, well, first of all, the regulations do not require a Part 91 owner to overhaul a TBO. And second of all, the owner, I suggested to the owner that he do overhaul the engine, and he declined to do so. And here's a piece of paper with his signature on it that says that's exactly what happened. I told him it should be overhauled. He said he didn't want to overhaul it. I can't force him to do it. It's not required by regulation. It doesn't affect the airworthiness of the airplane. And so that's what happened. And that piece of paper should take the mechanic basically off the hook for that, because the decision was not made by him. It's made by the aircraft owner, who's the person who's authorized to make that decision.
Kurt's wondering, have you heard of cases where not performing service bulletins on Part 91 aircraft has been used as a jury argument of having not taken a reasonable level of care?
Well, I mean, those sorts of arguments are made all the time if the case actually goes to trial. My experience is that these cases literally never go to trial. They always settle. And so they're in all of the expert witness work I've done over the last 20 years, there's not one case that actually went in front of a jury. The cases always settle. Sometimes in very extreme cases, hundreds and hundreds and hundreds of $1,000s of legal fees are expended on both sides, going through all the discovery process and all the settlement talks and all of that stuff. And they can get very expensive. But in my experience, they almost never wind up actually going to trial. Nobody, neither the plaintiff nor the defendant, wants to take a chance on what a jury's going to do, because it's so unpredictable. And in air crash cases, you're always dealing with juries that know absolutely nothing about aviation, because if there is a juror that knows anything about aviation, one of the two lawyers is not going to accept him. So you're dealing with a completely aviation naive jury, and anything can happen. And so none of the lawyers actually ever want these things to go to trial, because it's so unpredictable what will happen if it goes in front of a jury. And in every case that I've been involved with, the case is settled. Sometimes it's settled. Most of the time it's settled quickly. Sometimes it's settled not so quickly. I've been in a couple of cases that went on for 2 years before they settled, but they never went to trial.
John's wondering, does a typical A&P insurance policy pay the cost for defense of the lawsuit, or just payment to settle the suit?
No, they always pay for defense, and that's the main reason for having insurance. The likelihood of having an award against you is very, very small, but it may be expensive just to go through the process, and the insurance always provides for defense, and then that's probably the biggest benefit of the insurance, is providing a defense. And as I said, in my experience with my company, the insurance company has elected to hire lawyers and do lots of legal work preparing for defense even before a claim is filed. And in our case, we've never had a claim filed, but we've had quite a bit of legal expense preparing for a claim that might have happened but never did. And all that expense is borne by the insurance company, and it's totally their call as to how much legal effort to throw at one of these things ahead of time.
John's wondering, if suits are settled within the limits of insurance, why not buy the lowest amount of coverage that's legal and available as defense against lawyers looking for a big payday?
Well, that's a really good question, and I've had this conversation with my own attorney, our corporate counsel, some years ago. As I said, we carry $2 million worth of insurance, of liability insurance, and some years ago, we were doing a deal. I won't go into the details, but at any rate, we were we were working on a partnership deal with another company. And one of the preconditions that other company had of doing the deal with our company was that we increase our liability insurance to a minimum of $5 million. So I called my insurance agency and I said, could we, hypothetically, could we increase our coverage from $2 million to $5 million? And if so, what would the increase in premium be? And he said, sure, no problem. And he quoted me a premium increase that was breathtakingly small. I was really surprised. And then this deal fell apart. So we didn't actually have the requirement to do it. But I had a chat with my attorney and I said, well, gee, it's so cheap to get an extra $3 million worth of coverage over what we're currently carrying. Maybe we ought to do that. And the lawyer said, no, you don't want to do that. He said, you don't want to make yourself a more attractive target to be sued by having high insurance limits. He said, you're just about at the right level. Don't buy more insurance, even if it's cheap, because you'll just be more attractive target to be sued. So I'm not a lawyer. I'm just I can just relay what the advice I got from my lawyer, who's an aviation lawyer with a specialty in maintenance issues and been through this stuff a lot, knows what he's talking about, and so I trust him. But at any rate, that's a really good question. It generally doesn't make sense to overinsure. It just makes sense to insure enough to that the plaintiffs will be satisfied taking that amount, and then they'll go after the big pocket, the deep pockets. I mean, they always sue the manufacturers. They always sue the engine manufacturers. They always sue the propeller manufacturers, component manufacturers. All of those guys who will be carrying $10 or $100 million worth of insurance. Those are the real targets that they're after.
I've had a number of questions here from independent mechanics column, guys working out of the trunks of their cars, maybe just at very small airports. Chris asked the question, what's your opinion of the small airport mechanics conducting annual inspections with no liability insurance?
Well, I think it's risky. I would personally recommend against doing that. And again, the risk, it's important to understand that the risk isn't that somebody is going to get a huge damage award against you, because the chances are that's not going to happen. The real risk is that an airplane that you work on might crash. You will not have done anything wrong, but you'll have to hire a lawyer and go through a lot of stuff to demonstrate that you didn't do anything wrong, and that's expensive. And the legal fees can be it's not the damage awards that are likely to be life-changing for a mechanic, but the legal fees, if you're paying them out of your pocket, can be really pretty awful. So the reason that you want to have insurance is to cover your defense, not so much to cover the damage award, because the likelihood of a damage award is not very great. But the likelihood of having to hire a lawyer is much greater, and that's really what the insurance does for you.
Douglas is wondering, what kind of tort reform would you like to see? Do you have a solution to mechanics being unfairly held liable other than shifting liability to owners who know even less about maintenance?
Well, what I would like to see is a world in which in which the standard of care, if you will, is better defined. We have two standards. As a mechanic, back in the old days, all we had to do is worry about if what we were doing on an airplane was safe and whether it was legal being compliant with FAA regulations. Nowadays, we have to worry about, is it safe? Is it legal? And how will it look in front of a jury of people who don't know anything about aviation when the facts are spun by a talented and aggressive plaintiff lawyer to look as bad as they possibly can be? And that's kind of horrible. And I would like to see, at least in aviation, a change in the standard of care that says if a mechanic complies with the regulations and can show that he complied with the regulations, then he should be off the hook for whatever happens to the airplane. It's the nebulousness of the standard of care. I mean, the standard of care in a civil suit has nothing to do with regulations. It's this nebulous concept of, did the mechanic do something that a reasonable and prudent mechanic wouldn't have done, or did the mechanic fail to do something that a reasonable and prudent mechanic would have done? And so you wind up with a whole bunch of witnesses, expert witnesses on the stand, trying to define what a reasonable and prudent mechanic would have done or wouldn't have done. And then you've got this jury that doesn't know anything about aviation, doesn't know anything about maintenance, doesn't know anything about FARs, trying to digest this and weigh, where liability should be. And it's a very, very unpredictable process because the standard of care isn't clear. No two people are going to agree on what a reasonable mechanic would or wouldn't have done. And there's always this big battle of expert witnesses, which is in itself very expensive. So, I would like to see a world in which if you complied with the letter of the FARs, which is a well-defined objective standard, then you should not be liable, rather than having liability be based on this nebulous concept of the reasonable mechanic.
Gerald is asking, he says, I'm an A&P mechanic, am considering selling my personal Cessna 172 that I have owned and maintained for 17 years. Are there any steps that I can take before the sale that would minimize risk of a lawsuit should the new owner have an accident and try to place the blame on me? Airframe has 10,000 hours and engine has 2,700 hours since major overhaul, 100 hours since top overhaul. Engine is bore scoped at each annual and has oil analysis with each oil change.
Well, the most important thing you can do, and it doesn't really have anything to do with whether you're an A&P or not. This would apply to anybody selling an airplane. But the most important thing you can do is make sure that you have a good purchase sale agreement with the buyer, and that among other things, the purchase sale agreement makes it clear that you are making no representation that the aircraft is airworthy, and that that it is the buyer's responsibility to perform a pre-buy at his expense to determine the airworthiness of the airplane, that you're making no representation that the aircraft is airworthy. So he can't go back to you and say, well, you said it was airworthy, but 5 years later I discovered a nick in a connecting rod, and I'm going to come back after you about it. That's one of the big traps. Actually, it's funny because last week I was just having a dialogue with the chief counsel at AOPA, because they have a specimen purchase sale agreement up on their website, and one of the things that's in there is a warranty of airworthiness, which is something you never ever want to have in a purchase sale agreement. The seller should never be representing the aircraft as being airworthy. And if he does, it opens up this incredible slippery slope that can come back to haunt him years later. And I've been involved in some lawsuits about that. So that's the big thing. When you sell an airplane, you sell it as is, with a clear statement that you're not warranting its airworthiness, and it's the responsibility of the buyer to make an airworthiness determination prior to purchase.
And John's wondering, he says, I've had mechanics do the same task, for example, hanging flaps, and put the parts together in different orders after each interpreted the Cessna drawings differently. I've had one shop owner tell me that the Cessna drawings are merely quote unquote recommended procedures. What's your take on that?
Well, I'm not, I can't quite visualize what he's talking about in terms of parts assembly. I mean, normally the stack up of components when you put them together is well defined. Frequently you refer to the illustrated parts catalog to see the order in which washers and nuts and lock washers and things stack up. I don't know the specific thing that he's talking about, whether it's flap rollers or whatever, but I think there's most of those cases, there's a right way to do it, and everything else is the wrong way to do it. I don't think it's normally mechanics' discretion as to how parts are assembled. They're usually drawings that should make that clear.
We've had a few people chime in wondering, hey, what was wrong with your mag? What did you have to do to get your mag fixed? Well,
that's a long story that is subject of an upcoming webinar, actually. So I don't want to give it away here, but at any rate, it was an interesting experience. But I was able to take it all apart and put it all back together, and it after I put it all back together, it was working fine, and it worked fine all the way down to Florida and all the way back to California and up to Las Vegas and back. So I'm pretty sure it's fixed.
Oh, wonderful. And a couple people asked about Sam. They were just kind of wondering, is that what Sam's fear was, is being sued, or was it something else? Or don't you know?
I don't know. I can only speculate. There's a Sam out there. He knows who he is. Maybe he'll send me an email and explain his behavior. But short of that, I'm not going to hound him. And short of that, I can only guess at what he was thinking. But as I said, it wasn't a unique thing. It was something that I've experienced on many occasions before, both with respect to my clients' airplanes and actually myself as well, from the days back before I was an A&P and was dependent on these people. And the example I mentioned of when I got misfueled back 25 years ago is a real good example where, here I am, an aviator in distress, and nobody wanted to help me. And the reason they didn't want to help me is because they were scared to death of being involved.
Ron's wondering, what's your sense? What are the most common things that people get sued for in aviation maintenance?
Well, that's a really tough one. They get sued for all sorts of things, and most of the time it's all bogus, because 80% of the time that airplanes crash, it's the fault of the pilot. About 10% of the time it's the fault of the airplane, and about 10% of the time it's the fault of the mechanic. Those are kind of rough numbers, but they are kind of a merging of a whole bunch of different studies that have been done. But mechanics occasionally are responsible for air crashes, but not very often. But 100% of the time when an airplane crashes, and especially if somebody dies, the The family of the decedent winds up hiring a lawyer and bringing a lawsuit, and it's never against the pilot, who is almost always the actual person at fault. But they have to find somebody else at fault, preferably somebody with a lot of money, a lot of insurance, rather. That's what most air crash lawsuits are about. The plaintiff lawyers come up with some theory that it must have been a problem with the design of the airplane, so they can go against the aircraft manufacturer, or the design of the engine, so they can go across after the engine manufacturer, or maybe the maintenance, so they can go after the maintenance shop, although that doesn't happen nearly as often. I just finished being involved in a 2-year lawsuit. This is just a perfect example. It involved a crash of a large piston twin engine aircraft in Florida that happened, I don't know, probably happened 4 years ago. Killed the pilot. The pilot's parents were wealthy real estate developers. And so, of course, they brought a wrongful death lawsuit. Now, the reason the airplane crashed was because in the course of finishing up an annual inspection on the airplane, the shop that was doing the annual ran the engine and had no oil pressure. And then it ran it a second time and had no oil pressure. And then it brought it into the hangar and called Continental and said, we're not getting any oil pressure. And Continental said, well, here's what you got to do to prime the oil pump. And so they got the oil pump primed, and now it's making oil pressure. But they never did investigate to see whether those 2 runs with no oil pressure had done any damage to the engine. They never cut open the oil filter. They never did anything. And, on the second flight after the annual, that engine cratered. And when we did a forensic teardown of the engine, it was clear that it cratered because of oil starvation and really terrible things that happened. The engine was just in absolutely catastrophic shape. And it was clear that it was due to running with no lubrication. The family brought a lawsuit, and they sued the shop, they sued the aircraft manufacturer Cessna, they sued Continental, the engine manufacturer, they sued the company that overhauled the engine, they sued the propeller manufacturer, they sued everybody. The shop, who, as far as we were able to tell, was the actual, was the guilty party here, they settled out of the lawsuit within about 15 seconds for the limits of the $1 million limit of their insurance. And the lawsuit then proceeded to go on for 2 years against all these other defendants that didn't do anything wrong, but had a lot of money. That's the way these things always work. And so, like 2 weeks before trial, that lawsuit settled on, and I don't know how much it settled for, but I imagine it was quite a lot of money. But by all these companies that really didn't do anything wrong, but they had a lot of insurance, and their insurance carriers all got together and said, what is it going to take to make this go away? And we don't really want to go to trial because God knows what the jury's going to find. And eventually it did settle. That was the kind of the longest, most complicated suit I've ever been involved in. But all the defendants, I was representing one of the defendants. I'm not going to say who, but all the defendants that were in the suit after about the first 15 minutes were they were clearly not guilty of anything, but their insurance companies wound up ponying up a bunch of money to make the suit go away and prevent it from getting to trial.
Oh, let's see here. We got one from James. He says, I've participated in all owner-assisted annuals and performed maintenance under the direct supervision of an A&P with IA for the past 9 years. This year, with my A&P, IA tells me his insurance company is trying to restrict coverage to prohibit owner-assisted maintenance. Is this a new trend in the industry?
I'm not aware of that. I mean, it's entirely possible. It may be that his insurance carrier wound up involved defending some lawsuit that involved an airplane that had gone through an owner-assisted annual, and they spent a lot of money and decided that maybe they don't want to do that anymore. That's kind of the way things work in this business, that insurance companies will change their underwriting standards based on the losses that they actually have, trying to limit those losses. It would be interesting to ask the underwriter. You might ask your mechanic to ask his agent, try to find out why they've changed their standards, because it would be interesting to know that. And maybe they'll tell you, maybe they won't. But in my experience, that's usually what happens. Is a company, for example, I'm working very closely with an insurance underwriter right now that is known for writing very, very competitive insurance on general aviation airplanes, but they won't quote on my airplane. And it turns out that they had a bad experience a few years ago with an air crash involving an owner-flown piston twin, and made a decision they didn't want to insure owner-flown piston twins anymore. And they actually didn't actually say we won't insure any owner-flown piston twins, but they just raised their premiums to something that was not at all competitive. And so, so I'm not with that company. I'm with another company that quotes more competitive rates on piston twins. But these guys' rates on singles and even experimentals is very, very competitive. They're very frequently the low bidder or the second of the low bidder and stuff. So it's all based on what their experience, their loss experience is, as to how they set their underwriting standards. And sometimes they'll tell you, but they'll be willing to discuss it if you ask, and oftentimes they don't. They just say that's the way it is.
Mark is a freelance A&P. He's been helping a friend, somebody at the airport, restore an aircraft, and has been signing things off as an A&PIA. And it's getting to the end of the project now, and he's becoming a little bit concerned about his endorsements for this restoration. You got any advice for him? He doesn't have insurance. I don't really have any advice. If he's confident that the work he's done or the work that he has signed off is both safe and legal, that's the best he can do. If there was a case where there was work that he thought ought to be done that the aircraft owner declined to do, then he can, as I said, protect himself by having a letter between him and the aircraft owner, signed by the aircraft owner, stating that he recommended this, but the aircraft owner decided not to do it over his, contrary to his recommendation. And having a piece of paper like that would take him largely off the hook for those sorts of things, because it is the aircraft owner's decision. But that's about all I can suggest. Again, I think doing that kind of thing uninsured does leave you vulnerable to the possibility of having to spend money to defend yourself. And that's the reason that we buy insurance. It might be worth his while, checking to see what it would cost to get insurance, and see if he considers the premiums prohibitive. As I said, in my case, I was very pleasantly surprised at how low the insurance premiums that we pay are as a function of our annual revenue. It's not a really big number. It's not a really huge expense for us, and it makes me feel a whole lot better to know that we're insured. And I guess that's about all I can say. Mm-hmm. We've had a few people kind of chime in wondering about off topic here, but as a pilot, Kent says, my concerns are being sued related to taking someone up for a flight and something happens during the flight. Got any advice for Kent on something like that?
Well, again, that's why we as aircraft owners have insurance, and we should carry liability insurance. I always get a little bit concerned when I see people who have purchased aircraft insurance. And again, I'm not an aircraft insurance specialist. Don't put a lot of weight on anything I say here, but it always bugs me to see people who buy aircraft insurance where the liability insurance is something like $1 million limited to 100,000 per passenger, 100,000 per person, or 100,000 per seat, or something like that, because they have the illusion that they have $1 million worth of coverage, but they typically only have $100,000 worth of coverage, and that's really not enough. So the one comment I guess I would make for aircraft owners is, try to get what they call smooth coverage, which is where it doesn't have a per person or per seat, per passenger limit, sublimit, what they call a sublimit, that the overall policy limit, of $1 million or a couple $1 million, whatever it is something that will cover you regardless of who makes the claim against you. But again, the most important part of insurance is that it pays for your defense. And if your defense is good, then you won't have to worry about paying for a damage award. I guess that's all I can say. We have two options in dealing with risk in our lives. One is to be paranoid about it, and one is to insure against it. And my philosophy is you insure against it, and then you don't worry about it anymore. And you operate without having that cloud over you, because you know that you're insured, and the insurance will take care of it in the unlikely event something bad happens.
All right, Mike. Hey, we're pretty much at the end here, and I would just want to give you an opportunity now to make closing comments to everybody who is logged in.
Okay, well, again, the way I usually do this, I would invite you to sign up for our free monthly newsletter at savvyaviation.com, or if you hopefully stay online when Tim post the survey, there'll be a checkbox that you can check to receive the newsletter. If you don't like the newsletter, you can always unsubscribe. There's an unsubscribe link on every one of them, but it comes out monthly, and it's full of stuff, good stuff about maintenance and engine monitor data analysis and breakdown assistance and all the kinds of stuff that we deal with. My book that was published in 2014 is available at Amazon. It's called Manifesto, and it's just a short book about 100 pages long that summarizes my maintenance philosophy. I'm working on my engine book right now. Hopefully we'll be ready in time for AirVenture 2018. It's going to be a much bigger book. It's probably going to be 300 pages long. And it will be available on Amazon when it's published. Also hopefully be available to buy at AirVenture if you're going to AirVenture. And if you're interested in being involved in the process of creating the book, you can check out my site on Patreon, patreon.com/savvyaviator, and become a patron of my writing efforts. Upcoming webinars on the next first Wednesdays of the month. In February, I'm going to take another pass at my Manio non-functional magneto story and tell you the rest of the story about that, and tell you a couple of other stories about that I think you'll find interesting. On March 7th, I'm doing a webinar called Making Metal Behave, where we talk about all of the various ways that we can change the characteristics of metal to make it harder, softer, springier, tougher. Getting into things like heat treating and cold rolling and all of that sort of stuff. A little bit of metallurgy and few SN diagrams and some stuff just to for the nerds out there, and we'll just get kind of deeply into, or semi deeply anyway, into what makes metal act like metal and how we change its characteristics to make it to make the characteristics suitable for the application that we have. Metal's really interesting stuff, and that's what we're going to be talking about in March. And in April, we're going to do a webinar called "Don't Shoot Yourself in the Foot," and it's all about how aircraft owners tend to sabotage the maintenance of their airplanes, and with a couple of lessons of things you should try to avoid doing when you're dealing with aircraft maintenance. So that's pretty much it, Tim, and look forward to seeing everybody in February. Happy New Year.
That sounds great, Mike. Thank you so much for being with us again tonight. Starting out 2018 off the right foot, it was a great presentation. And we look forward to next month and when we hear the rest of the story about the Magneto. And to everybody who tuned in tonight, thank you so much for joining us, and hope you can tune in next week. Have a great night, everybody. See you next time.
Thanks, everybody, for coming. Good night.